The News4Jax I-TEAM is learning more about the history of the condo through documents just released by the town of Surfside. They include permits for the original construction and repairs. I-TEAM investigator Tarek Miner explains how the builders are protected from being held liable. Tarek.
So we know that the Condo Association hired companies in 2009 and around 2001 to do concrete restoration work on the balconies. That included fixing cracks in stucco and painting. Now, we've also learned that back in 1980, as the condo was first going up, work had to temporarily stop on the penthouse unit at the very top. In a letter dated December 2nd, 1980, the acting town manager of Surfside ordered builders of Champlain Tower South to immediately cease any further construction on the penthouse. The town attorney at the time writing, "This is a violation of the code of the town of Surfside." 9 days later, after the town council granted an exception, work was allowed to resume. But in May of that year, the property owner requested the original permit be canceled because the contractor hired to complete the project resigned. The new contractor then applied for another permit. The News4Jax I-TEAM has learned the state agency that regulates contractor licenses imposed several fines on the new contractor in the 1980s after this project was completed. And 3 other investigations led to the voluntary relinquishment of his state contractor license in 1998. The I-TEAM has asked the state for documents regarding all of these cases. It remains abundantly unclear what caused the 12-story building to collapse, resulting in the deaths of at least 16 people inside the condominium who were likely asleep. What is clear, however, is that the original builder, architects, and engineers are immune from any legal liability, according to construction and condominium attorney Barry Ansbacher.
But under Florida's law, which is very protective of the building industry, there's a short window that you can bring claims. In general, you have 4 years from when you discover there's an issue. But even if it's completely hidden and you have no idea that there's a defective condition, 10 years after the building is completed or the project is turned over, that is the end of any liability that the builder or design professionals would have.
The state attorney in Miami plans to have a grand jury examine the condominium collapse. Lawyer G. Nichols, who's not associated with the case, says it could result in criminal charges and also give investigators the additional information they need.
We know that grand juries have the ability to do investigations of situations, events, public officials in order to come back with what is typically called a presentment or a report. So what you can expect is at some point in time, the state attorney will impanel a grand jury, and what that means is this group of individuals will be in a position to investigate on behalf of the Miami court system.
So grand juries in Florida can do a number of things, including returning indictments on criminal matters and exploring issues of public policy. The legal experts say the grand jury's findings will also be helpful in recommending changes to lawmakers to ensure that something like this never happens again.